Good morning, everyone, and welcome to Radcliffe Chambers Private Client Webinar. I'm Matt Mills, and joining me in the commentary box is Olivia Wilson. Good morning, Olivia.
Good morning.
Today, we'll be talking to you about two different topics in private client practice. Olivia will speak first about deathbed gifts. I will then talk about the role of trustees and PRs in private client litigation. After that, if time permits, we'll be happy to take any questions from you. If you'd like to ask us something, please click on the Q&A button at the bottom of your screen and type your question. Don't worry, only Olivia and I can see it. Without further ado, I'll hand you over to Olivia.
Great. Thank you, Matthew. So today I'm going to be talking about the rights and wrongs of deathbed gifts. Sometimes these are referred to as donatio mortis causa or DMCs. I'm not sure if others of my generation relate to this, but when I see DMC written down, my knee-jerk reaction is to read it as a deep and meaningful chat. So today, this talk is essentially a DMC about DMCs. I'm going to give some particular focus to a 2024 case called Rahman and Hassan. In my opinion, quite a controversial case and raises some interesting points. And it has been given permission to appeal. And the Court of Appeal listing, I believe, is coming up on the 23rd of October, so about a month's time from now. So very broadly, a deathbed gift is a gift made by someone in contemplation of their impending death. When done successfully, these gifts don't form part of the estate vesting in the personal representative, but instead pass directly to the donee. It's therefore a mechanism where people can make these gifts that take effect on death, but are outside of the provisions of their will or the intestacy rules. This doctrine stems back to Roman law. It's always nice to be reminded of the long history of our sector. Broadly, there are sort of 4 steps that need to be satisfied for a deathbed gift, and I've popped those on the screen. So first, it needs to be made in contemplation of the donor's impending death. Secondly, it needs to be conditional on the death of the donor. Thirdly, there must be a parting with the dominion over the subject matter of the gift. And finally, obviously, the donor needs to have capacity to make the gift. So I'm going to deal with these in turn in a little bit more detail. Firstly, gift needs to be made by the donor in contemplation of the donor's impending death. Now, this is subjective and requires the donor to anticipate death in the near future from an identified cause. So it doesn't need to be an inevitability. So, for example, if there's an illness or a risky operation and there's a chance that the donor may well survive, that is sufficient. You don't need to sort of have a crystal ball that tells the future. And the gift needs to be made in the expectation of death from a probable cause, for example, cancer. That won't necessarily be invalidated by reason of death occurring because of something else like pneumonia, unless it was very specific that it was conditional on the donor dying from cancer, for example. A person who is just simply nearing the end of their lifespan may not be sufficient. For more discussion on this particular requirement and a bit of a summary of what's needed, Lord Justice Jackson's judgment in the Court of Appeal case of King and the Chiltern Dog Rescue and Redlands Sports Sanctuary is one that I would suggest having a quick look at, and I've got the citation on the slide there. So the gift also needs to be contingent on the donor dying. The gift only takes effect once the donor has died, and the gift is revocable prior to the donor's death. So what happens if the donor doesn't die when expected? Well, it automatically lapses. So, for example, risky operation and the donor anticipates that they're going to die, but the operation happens and the donor survives. Any deathbed gift that was purportedly made will lapse. The courts have been willing to infer the conditionality of the gift from the circumstances of the case. So, for example, in Sen and Headley, which was a 1991 case, the donor said, "The house is yours, Margaret." The court didn't require the donor to have said something like, "The house is yours if I die," which I'm anticipating. The circumstances around the case were sufficient to imply the conditionality of death. So the donor also needs to part with the gift or deliver it in some way to the donee, or the essential indicia of title, which amounts to a parting with the dominion and not mere physical possession. So there are a couple of ways that this can be done. The court has accepted, for example, actual delivery, so handing over jewellery, here is this ring, here is this necklace. The court has also accepted constructive delivery, so providing some means of accessing the subject matter, and commonly that would be a key. The key is providing the means of making use of the possession. However, obviously there are some things which aren't capable of delivery by either actual or constructive delivery. And the courts have accepted where it can be shown that the indicia of title has passed by delivery. Birch and Treasury Solicitor's 1951 case said the indicia of title, as distinct from mere evidence of title, the document or thing, the possession or production of which entitles the possessor to the money or property purported to be given. And that was at paragraph 308. These concepts and the actual practical application of indicia of title and dominion are not easy ones. It's probably one of the more troubling aspects or most difficult to grapple with when you're looking at deathbed gifts. In fact, in Valley and Birchwood, which is a 2014 case, they were described as slippery. So it tends to be something that's more than just possession, but it doesn't need to be legal ownership, transfer of legal ownership. When we talk about delivery, it's also, as a sort of secondary part to that accompanies it, the subject matter itself of the gift obviously has to be capable of being given away in this manner of one of these three ways. So either actual, constructive, or sort of by dominion passing by delivery of the indicia of title. And it's not entirely clear how some assets would satisfy that requirement. Prior to Sen and Headley, one of the cases, it was generally thought that land could not be subject to a deathbed gift. However, the Court of Appeal in Sen and Headley found that handing over the title documents to unregistered land was sufficient to find that a deathbed gift had been made. In that case, the donor, during his last illness, told his partner of 10 years, who was the donee, that his house was hers. He gave her the sole key to a still box containing the title deeds to that property. She already had a set of keys to the house itself. But this case was considering unregistered land. Since the Land Registration Act 2002, there was a debate as to what would be required for delivery of indicia of title of registered land, or indeed if that was even possible. And I will return to this point when discussing the case of Rahman and Hassan. So finally, on the requirements, those sort of four bullet points that I had on the first slide, is capacity. This isn't always listed, but I think it's worth raising that, of course, the donor needs to have sufficient mental capacity to make a deathbed gift. The capacity requirement is that for a lifetime gift. So that rather than, for example, testamentary capacity. And the question of capacity was set out in this case really new. As with, for example, litigation capacity, it's issue specific. So the level of understanding required will vary depending on the transaction in question. So is the value of the gift trivial, or is it really significant, such as transferring a family home that might be the only valuable asset of that estate? In Re v. the court found that if the donor is disposing of their only asset of value, then the degree of understanding required is likely to be similar to that of making a will. They need to be able to understand the claims of all potential donors and the extent to which the property is being disposed of. So just briefly touching upon the relationship between the donor and the donee, if the legal title is actually transferred to the person who's receiving the gift, then until the donor dies, because that's when the gift takes effect, they'll be holding it on trust for the donor. If the legal title isn't transferred and it remains with the donor, then when the donor dies, the legal title vests in the personal representative, but they'll be holding it on constructive trust arising by operation of law for the donor. As I've said, the deathbed gift can be revoked prior to death. This can be automatic, so when they, for example, recover from an illness, or it can be obviously expressed. So the donor takes back the property, expresses their revocation, but just taking it back for example, safekeeping, that's not sufficient. And a deathbed gift can't be revoked by the will either. So those are the sort of requirements and basic principles of a deathbed gift. I'm now going to talk specifically about Rahman and Hassan, this 2024 case, because it raises some interesting points. But first, I will just briefly go through the facts. So the deceased made a will in 2015, which left his UK assets to his wife's 3 nieces and her brother. The deceased's friend, who was also actually a distant relative, brought a claim against the estate, alleging that a deathbed gift had been made to him, comprising of assets including real property, cash held in an online bank account, and shares in an online account as well. The first and second defendants were the executors and beneficiaries of the deceased's will, and the third and fourth defendants were the additional beneficiaries under the will. This alleged deathbed gift was made when, following the death of the deceased's wife, the deceased instructed a will writer on the 15th of October 2020 to draw up a new will under which the claimant was going to be the sole executor and beneficiary of the estate. The will writer was then scheduled to return on the 22nd of October 2020. Following the days since the will writer had visited the deceased's place, his health was declining, and he expressed that he didn't think that he had very long to live. Then on the 20th of October 2020, the deceased provided the claimant with the registered land certificate for a property and said it was for him. The deceased told the claimant where the spare keys to the house were, although the claimant and his wife already had a set of keys. And the deceased also provided logins and passwords to various online banking accounts, as well as leases to 2 flats. As I say, the will writer was scheduled to return on the 22nd of October to execute the will, but there was an issue with securing the witnesses for the will's execution, and therefore this new will was never formally executed. The deceased took further steps following the cancelled meeting and sent 2 messages, one to the will writer themselves saying, "Jonathan, I am Al Mahmood. I agreed that Masood Rahman will be the absolute owner of all my assets and the executor of my new and last will. This is my final word. I revoked all my previous will done by me and my wife. It's a difficult time for me. Please help Masood." And he also sent a text to his friend saying, "Masood is my son. He is the absolute owner of all my assets. This is my final word." The deceased then died a day later on the 23rd of October. So that's the factual background for this case. It was heard by His Honour Justice Matthews, who found that the claims succeeded, except in relation to the furniture and other contents inside of the house and the flats. He found that the deceased had made a gift in contemplation of his impending death that was conditional on his death, and he had parted with the dominion over the subject matter. There was therefore multiple valid deathbed gifts. I'll just touch briefly on the reason why the furniture inside the contents of the house weren't found to have been gifted, and then I'll return to some of the interesting points over subject matter of these deathbed gifts. So there was insufficient delivery for the chattels inside of the house and the flats, and that's why it was deemed not to have been a deathbed gift. The authorities relating to gifts of chattels demonstrate the importance of being able to establish sort of delivery amounting to parting with dominion of the thing given. And therefore, there hadn't been sufficient delivery of the chattels inside of the properties. His Honour Judge Matthews did find at first instance that the handing over of the land certificates was sufficient indicia of title to pass this property. As we've said, previously the courts had established that unregistered land could be gifted through the handing over of title deeds. However, in this judgment, it was sufficient to hand over the land certificate in respect of registered land. Prior to this, the topic of registered land and deathbed gifts was yet to have any solid authority. And given the introduction of the Land Registration Act 2002, there's no need, or there is no land registry certificates, as the title register is sufficient, or is the title. And so in this judgment, the handing over of these land certificates were sufficient to pass the indicia of title to registered land. In fact, and I've put the quote on the slides, the judge went even further. And although this is an obiter paragraph, I do think it is quite controversial because he stated, "It is not necessary for me to decide what would have happened to the gift of the house of Mr. Al-Muhammad had not had the land certificate. But I may say that, as at present advised, I would have held that the handing over of an office copy entry of the register with the relevant donative intent would have sufficed. I've also said that there is no difference between unregistered and registered land." While there's yet to be sort of clear authority on this point, and it was obiter, it's my opinion that it would not be sufficient to have an office copy entry of the register. Land certificates are one thing, or indeed title deeds. They're clearly quite different from an office copy entry, which anyone can get hold of for a small fee. It's not entirely clear to me how that would be sufficient indicia of title, or therefore be sufficient to satisfy the requirement for parting with dominion. The judge stated that the real question is with what intention was the document handed over? And while I agree that there is importance to intention, surely what the document is and whether that parted with dominion is really the crux of the issue. In Rahman and Hassan, there were also 2 flats, and there were no land certificates in relation to these, but long leases instead. And the deceased had the long leases themselves and some supporting documentation, including official copies of the register. The judge stated that I can see no good reason why, merely because the leases are registered, they should not be indicia of title and have a similar evidential value. Original copies of the lease, in my mind, may be sufficient, but there is a question of, is this really enough to be passing indicia of title? The other area of particular interest is the online accounts. And regarding the online accounts, the judge found that the login and passwords were the indicia of title in the computer age. Regarding parting with dominion, the judge commented that due to the deceased's condition, it was not possible for the deceased to have memorized all of the logins and passwords. And accordingly, by handing over those records, that had these all laid out, and he put it out of his own power to deal with those accounts. To me, this seems like quite a leap. Can the parting of dominion over the property really be determined by the frailty of the donor? The judge relied on the Court of Appeal case of Woodard and Woodard, which is a 1995 case, and drew from that even if there were several keys, for example, a car, which was the subject of the DMC, the question is, what intention was that particular key handed over to the donee? Was it to share access? Was it to give short-term authority, or was it to make the gift of the car? And so he returned again to this question of intention. I personally do have some concerns about passwords and logins being sufficient for online banking to pass indicia of title. Remembering your password isn't necessarily absolute for access. Passwords tend to be retrievable. So is this sufficient? Also in Woodard and Woodard, they already had possession of the car, and therefore I think that is quite different to the situation faced here, and indeed regarding online banking accounts. So, as I mentioned, this case is currently under appeal, and in my opinion, somewhat unsurprisingly, given that there is a fair amount of uncertainty in the judgment. Permission to appeal was granted by His Honour Judge Matthews, and the defendants put forward 8 grounds of appeal, and permission was granted on 5 of those grounds, which I had put on the slide. So I've numbered them based on the grounds of appeal. So 2, 3, 4, 5, and 8 were given permission. And they were that His Honour Judge Matthews was wrong to hold that the land certificates or copies of leases were indicia of title rather than evidence of ownership. That the judge was wrong to hold that the passwords to online accounts and bank cards were indicia of title, and that the judge was wrong to rely on his judgment at paragraphs 150 and 158 on the decision of Woodard and Woodard, and the judge was wrong to consider the key question regarding transfer of dominion and indicia of title was one of evidence of intention. And again, sort of more broadly, that the issues raised in this case are quite novel, and the decision is going to set a precedent of importance. Therefore, we are awaiting more authority on what amounts to indicia of title for the purpose of the deathbed gift, including these subject matters, which don't have extensive authority so far. Some have raised concerns with the doctrine of deathbed gifts, that it is vulnerable to abuse and fraud, and the Law Commission did consider the matter in its Modernising Wills Law Volume 1 report, which was ordered by the House of Commons to be printed on the 15th of May 2025. But the Law Commission did not recommend any modification to the current law on deathbed gifts. The Law Commission actually said at paragraph 15.4, confirmed that weight should be given to testamentary freedom, and it was considered that the court's current approach provides adequate protection and addresses these concerns by being careful not to extend the application of the requirements. The Law Commission stated that we think that there is a role for the doctrine's continuing application. I've also read some opinion that these deathbed gifts may well be used less frequently in light of the Law Commission's current discussions around a dispensing power, so being a power for the court to recognise a will, and despite non-compliance with formality requirements. I'm not convinced that that's going to change the landscape of deathbed gifts significantly, and they're already not, a wholly common occurrence. So I don't think it will have a great impact, in my opinion. So it doesn't seem that there is much appetite to abolish the doctrine in whole. We therefore await the Court of Appeal, which may either restrict the doctrine so that only some forms of property are capable of passing by deathbed gift, or alternatively, it may well extend it to include more forms of property. So Rahman will certainly move the doctrine along one way or another. So watch this space. I will now hand over to Matt.
Thanks very much, Olivia. Good morning, everyone. As we all know, despite their best efforts, both trustees and PRs sometimes find themselves involved in litigation. Common types of claim include debt, estoppel, constructive trusts, Inheritance Act claims. In this webinar, I'll talk to you about the steps which trustees and PRs can and should take when dealing with claims of that nature. Now, first things first, we need to establish how a trustee or a PR might become involved in litigation. I'll discuss trusts first and then PRs second. Now, it's obviously impossible to fit every conceivable claim into a few neat categories. Nevertheless, in my view, there is a helpful starting point. In the decision of Alsop, Wilkinson and Neary, Mr. Justice Lightman said that in general terms, trustees might be involved in three types of claim. The first one he called a trusts dispute, which he said related to the trusts on which the property is held. Now, he said this could be friendly or hostile. An example of a friendly trust dispute is a claim to interpret the trust itself, whether or not the parties actually agree. Examples of hostile trust claims include challenging the validity of the trust, say for undue influence or mistake, a dispute over whether an asset is or isn't part of the trust, this might be your estoppel, and a claim by one beneficiary to another beneficiary's share. The second category is a beneficiaries dispute, and that's where one of the beneficiaries complains about something that the trustee has done, has not done, or is proposing to do. Common examples in this category are removal claims and claims for breach of trust. Our third category is a third-party dispute, and that relates to the rights or liabilities that the trustee takes on while administering the trust. So, for example, they might be liable for breach of contract or tort for their actions, or they might get involved in a boundary dispute or a possession claim relating to a trust asset. Now, these categories are all very easy to state and for me to put on a slide, but they are quite difficult to apply in practice. Let me give you some examples. A claim by a third party to an asset of the trust isn't a third-party dispute, even though it involves a third party. It's a Category 1 trust dispute. And sometimes what looks like a Category 1 will interpretation claim might in fact really be a Category 2 dispute over how the trustee has been administering the trust. Another complicating factor is that over time, a claim can morph from one into the other. It's not fixed once and for all. Nevertheless, I do think this is a useful rough categorization of the types of claim that you might face if you or your client is a trustee. So that's the position for trusts, but what about the position for personal representatives? Fortunately, authority tells us that the Alsop-Wilkinson categories equally apply to PRs. So, for example, a Category 1 trust dispute would be a probate claim over the validity of the will or a claim for the proper interpretation of that will. A Category 2 beneficiaries dispute could be a devastavic claim against the personal representative, and a Category 3 third-party dispute could be a claim for breach of contract or tort against the PR for how they've administered a part of the estate. The one difference here, though, is that, as you know, personal representatives inherit essentially every claim that could have been brought against the deceased, except for a few categories. Now, the main exceptions, as I'm sure you know, are defamation, personal contracts, so for example, contracts to make art or music, and purely joint obligations. But other than those exceptional circumstances, essentially everything you can sue a person for, you can sue their executor for, and that might fall within the scope of our Category 3 third-party dispute. So those are the broad categories of litigation. With that background in mind, let's drill down into the detail of some common types of claim, and we can see what trustees and PRs should and can do. Let's start with contract and tort claims. These are your Category 3 third-party disputes. Let me give you some examples. For example, a personal representative might enter into a contract with an estate agent in relation to the sale of the property, and they might breach that contract in some way, for example, by going elsewhere. Another example would be if a trustee negligently undertakes some work on a trust asset, and that causes somebody physical injury. Now, there are two very important things to bear in mind about contract and tort claims against trustees and PRs. The first thing is, trustees and PR's liability is not limited to the amount of the trust or the estate. It's not limited. You are liable for the full amount. Similarly, there is no defence of I was only acting in accordance with the will or the trust. That's not a get out of jail free card. The simple rules of breach of contract and tort still apply. However, as a trustee or PR, you may be able to claim an indemnity for any damages that you need to pay. Broadly speaking, the test for breach of contract is whether the contract was properly made in the course of the administration. And broadly speaking, the test for tort is whether your actions were reasonable, you showed due diligence, and you acted within accordance with your powers. Now, it's not easy to prove these things, but there is a way that you can end up indemnifying yourself as trustee or PR for the damages you might have to pay. But obviously, this shows you it's pretty high risk. So with that high risk in mind, how should a trustee or a PR deal with a contract or tort claim against them? Now, the starting point is that they have a duty to represent the trust in a third-party dispute. And that then leads into fairly typical costs provisions. So, for example, if you defend the claim and you win, you will usually get an order for costs in your favour. But what if you lose? Or what if there are some irrecoverable costs because you only get costs on the standard basis? In a nutshell, you can take those irrecoverable or adverse costs out of the trust or the estate if you properly defended the claim for the benefit of the trust. That is the key test to apply here. Were you properly defending the claim for the benefit of the trust? Now, what on earth does properly defending the claim mean? Well, there is no hard and fast answer. But in my view, there are 5 ways that you can go about proving this and protecting yourself as trustee or PR. Number 1, if all of the beneficiaries are adults with capacity, you can ask them to give their written consent to what you propose to do. If they do, you've usually got good protection. Alternatively, if it's particularly high value or complicated, you could apply to court for a Beddoe order, which authorises you to take or defend proceedings. Thirdly, if the beneficiaries can't or won't consent and a Beddoe is just too expensive, you could try and compromise the claim using your statutory power and then reduce the amount of exposure for the trust, the estate, and you. The fourth option is, in theory, what you can do is just get counsel's advice, and if it is clear-cut, claim that it is properly defending the claim by relying on that advice. Now, that's an old case, and in my view, you'd need to continue to ask counsel for updates throughout the life of the claim to make sure they're still telling you it's correct for you to be doing this, but that is one option. The fifth, more high-risk option is basically just plough on ahead, and then at the end of the trial argue that you properly defended it for the benefit of the trust. And that's obviously high risk because you haven't laid any of the groundwork out in advance. But it might be appropriate, for example, if the claim you're facing is obviously speculative and going to be struck out. There's no point going through the process of getting a Beddoe order if the claim is just going to be struck out at the first hearing. But obviously 5 is very high risk because if you lose, it's going to be pretty tricky to argue that ploughing on regardless was properly defending the claim. So although it's an option, it's unlikely to be that safe to rely on it. So that's contract and tort. Let's move on to another type of claim. As I said earlier, almost every claim against a deceased person can be brought against their executor. In practice, whether or not you've yet got a grant, the named executor is the appropriate defendant. And it doesn't matter if the grant is only limited for a certain time or for certain steps, you are still the most appropriate defendant. Now, if you are a personal representative and you're faced with a claim relating to the estate, you've got 5 main options. And what we'll see is these options are pretty similar to the ones I've just shown you on the previous slide. Option 1, you can just accept the claim. If it's a good one and should be paid, accept it and pay it along with the other estate debts. If you have some uncertainty, you can seek counsel's advice, but sometimes it's just clear enough. Alternatively, if it's a bit dubious but there's some merit, you can compromise it using your statutory power and avoid the costs of counsel and proceedings. Alternatively, as I said before, if all of the beneficiaries are adult and have capacity, you can get their written consent to a particular course of conduct. Or if it's particularly difficult or high value, you could try and get a bedo order. But the fifth option is unique to personal representatives. If this claim is brought quite late and you have already distributed the estate, you should rely on the defence of plene administravit, excuse my Latin. What it basically means is administration complete. And that defence means your liability is limited to the amount that you have in your hands at the time of the claim. And if at the time of the claim you've distributed everything, you've got a pretty cast iron defence there. So that can often be the simplest for late claims brought against a personal representative. A tricky issue arises if you're a trustee and somebody challenges the validity of the trust under which you act. So remember, this would be a Category 1 trust dispute. Now, the first thing you need to do is bear in mind the difference between a void trust and a voidable trust. Void means the trust never existed. Voidable means it can be set aside at a later date by the court. Now, this really matters because if the trust is voidable, the trustee is entitled to the cost of administration up until the date it's set aside. But if it's void, the default rule is you get nothing. You have to rely on the discretion of the court to allow you some or all of your costs of administration, and you might not get that. So that's why the first thing you should always do if you're a trustee is ascertain, would this be a void trust or a voidable trust? Another risk to bear in mind is if you've been alerted to a challenge to the validity of the trust, you can be personally liable if you continue to make distributions which are later set aside or challenged. So do be careful. With those risks ringing in your ears, what should you do? Well, the first thing you should do is try to conduct as good an investigation as you can. Now, in practice, I suggest what you do is you ask the potential claimant to set out their case in writing with any evidence they have. You then investigate other sources that are open to you. So you might be able to speak to other beneficiaries or previous trustees, or get bank records or medical records. And if needs be, seek counsel's advice. That would give you a really solid base from which you can work. But what you need to do depends really on whether that claimant issues the claim or not. So I'll talk about those two options in turn. If the claimant does issue a claim, you shouldn't make any distributions until that claim is resolved, especially if the trust could be void. You should also try and steer clear of any really important investment or other decisions of that nature. Because again, if it's all void, that could come back to haunt you. And generally, the court will expect you as trustee to remain neutral and to let the beneficiaries fight out the validity of the trust. But sometimes that won't work. There might be minors or unborns, or the beneficiaries just might not want to fight it. In that situation, what the trustee can do is ask the court if it would like to authorise the trustee to act as defendant on behalf of the trust. But only do that if the court authorises you. Otherwise, you are at risk of an adverse costs order. A procedural point that sometimes comes up is that a third party might only sue the trustee, in which case you can't just sit back and do nothing because the claim could go by default. So in that situation, what I recommend is that at the first CMC, as trustee, you suggest that the court joins at least the main beneficiaries so that they can then take over conduct of the defence and you can remain neutral. So that's what happens if the claim is issued. But what if a third party threatens a claim but doesn't do anything about it? Or you've just heard of the possibility, but no one's taking any steps? Well, in those situations, you have three options open to you. Option 1 is just ignore the claim if it is almost indisputably a bad one. In practice, what this means is it's going to be struck out. That's obviously high risk, but it is technically the law. A middle ground is you ask the adult beneficiaries who are of means to give you an indemnity. And if you think that indemnity is worth relying on, you can plough on and then call on that indemnity if you need it later. Alternatively, you can seek some sort of order from the court. And there's actually quite a few options open to you here. You could get a better order, which authorises you to litigate or defend. You could ask for a stakeholder order, which sets up proceedings which determine to whom the trustee should pay the money, the beneficiaries or this third-party claimant. Or you could get a Benjamin order, which allows you to distribute the money notwithstanding the potential claim. Or you could get a put-up or shut-up order, which requires the claimant to issue their claim within a certain period, failing which you can distribute safely. So that's the position for challenges to the validity of a trust. But what about challenges to the validity of a will? The general rule is that executors should remain neutral in a probate claim. And if someone issues the claim, that means it's quite easy. Usually you just sit back and let the potential beneficiaries of the different wills or intestacy fight it out. But what if somebody vaguely threatens to challenge a will but doesn't issue? Or you have suspicions, but nobody does anything about it? Well, in that situation, you have broadly two options open to you. Option 1, if you haven't yet started administering the estate, do nothing. You are not obliged as an executor to take on the administration of an estate or to start a probate claim. And your failure to do this does not disentitle you from later getting a grant of probate when the dispute resolves itself. So a lot of people will take this course if the dispute is raised at an early stage. They'll just say, not my problem. But even if you are going to try and take this dispute, you will be expected in some circumstances to act. So for example, if the claimant and beneficiaries want the will writer's file, the will writer will likely need your consent to give that up. So you'd probably need to cooperate there. Your second option is to issue a probate claim to prove the will in solemn form, join all of the beneficiaries of both wills as defendants, and let them fight it out. Essentially start the claim and take a step back. Further, or alternatively to these three, you could also try and seek indemnities from the beneficiaries, if they're good for the money, and proceed on that basis. Once a probate claim has been issued, you've got two main obligations. One is you should offer to take reasonable steps to secure and protect the estate pending the resolution of the claim. That might be, for example, insuring assets or putting cars in storage or making sure that squatters aren't getting into the property by sending people around to check on it. Things like that. You must also not make any distributions from the estate, because if you do and those are later challenged, you can be personally liable for the amount that you've distributed. And in fact, it's possible for a claimant to get an injunction to stop you making wrongful distributions. And as we all know, interim injunction applications are urgent and stressful and expensive. Try and avoid that if you can. Let's move on to another type of claim. Sometimes a third party will not actually challenge the trust or the will itself. They'll simply point to an asset and say, that's actually mine. Two common examples of this are constructive trust claims and proprietary estoppel claims. Fortunately, in practice, what a trustee or a PR should do is exactly the same thing as what I've just described in a challenge to the validity of a trust. In other words, if the third party issues that claim, you should invite the beneficiaries to be joined and let them fight it out and remain neutral. But if the potential claimant refuses to actually issue any claim, your options are ignore it if it's speculative, rely on the indemnities that you can get from the beneficiaries, or seek some sort of order from the court. And you remember the list of 4 things I put on my previous slide. So this all should be very familiar. You adopt the same approach to estoppel and trusts as you do to a challenge to the validity of a trust. Finally, I wanted to talk about claims under the Inheritance Provision for Family and Dependents Act of 1975, and I'll break it down into a few different parts. The first thing to talk about is people. It is perfectly possible for a personal representative to be a claimant in an Inheritance Act claim. You do not need to renounce your grant of probate. A common example of this would be a surviving spouse who's appointed executor but only left a life interest in the matrimonial home. That's commonly the start of an Inheritance Act claim. Similarly, it is perfectly possible for a defendant to be both a personal representative and a beneficiary. And such a person should usually have one set of lawyers rather than two, unless there's some sort of conflict of interest. Now, importantly, the guidance suggests that it's for the lawyers to monitor this conflict of interest. So if you have this situation on your books, do periodically check that you're not suffering from a conflict of interest or your client isn't. If you are acting for someone who has two capacities, make sure that you record your time separately for each capacity. In practice, if your client is the claimant, they're probably not going to have any PR costs, so that's quite easy. So this really only matters if your client is a defendant beneficiary PR to an Inheritance Act claim. So those are people. Let's now move on to timings. As I'm sure you know, a personal representative will not be liable if they distribute the estate more than 6 months after the grant of probate. Now that 6 months is always 6 months. You can't bring it forward by relying on your notice in the Gazette, for example. Importantly, once you have notice of a claim, you can be liable for doing anything that prejudices that claim. And as a result of all of this, it means it's usually prudent to wait around 10 months before distributing an estate, because that allows the 6-month period for issuing the claim to elapse, and then a further 4 months for the service to elapse. That said, you shouldn't treat this 10-month rule as an absolute prohibition. Remember, your duty is just don't prejudice the claim. It's not do nothing. And there are lots of things that you might be able to do that don't prejudice the claim at all. For example, paying very small legacies that are never going to be challenged, or giving some bequests that are again never going to be challenged because they relate to personal items with no monetary value. Or you might have a beneficiary who is basically got a cast iron defence to an Inheritance Act claim. Say, for example, a young child of the deceased who's disabled and really needs the money for their care. You might feel confident in simply paying those. Now, if you have any concerns over whether you should make payments of this nature, you can write to the claimant and say, this is what we're proposing to do. Please confirm you don't object. If they give that confirmation, happy days. If they don't, that can be used against them on the question of costs later on, and that might give you some protection in whatever decision you choose to make. The final thing to bear in mind for timing is don't forget you can get a put up or shut up order to force somebody to issue an Inheritance Act claim within a certain period. Now, usually this isn't necessary because the 6-month time period forces people to get on with it, but sometimes people threaten even after the time period has expired, and this can be one way of dealing with a particularly extreme case. Let's now move on to evidence. Once a claim has been issued, if your client is the defendant PR, they must file the evidence required by Practice Direction 57. In a nutshell, this is information about the estate and the beneficiaries, and any other matters which might affect the court's discretion. You might also be required to file the original grant of probate at the court. And if you are, look in the Chancery Guide because it gives you very clear guidance on exactly what you need to put on the envelope and where you need to send it to ensure it's not lost or shredded. Now, Practice Direction 57 technically says you should include any evidence that might affect the court's discretion. But if your client is a PR, be very, very careful about saying anything which could be construed as trying to defeat the claim. That's because the golden rule is that the personal representative should take a neutral position and assist the court. Your job is not to represent the estate beneficiaries. They have their own interests. They can get their own lawyers if they need to. If you are going to be neutral, as you should, say this at a very early stage in your acknowledgement of service. And if the estate is small, the court will expect you not to pay any lawyers to go to trial, just to sit there and say that you're neutral. So do bear that in mind when it comes to things like cost budgeting and resource allocation. But just because you're being neutral doesn't mean you have to sit back and do nothing. Do keep the other parties and the court informed on any updates to the estate. For example, any claims against the estate or any valuation changes or assets that are lost or recovered. Do let people know at the reasonably soonest opportunity, because obviously the size and nature of the estate is a key factor in an Inheritance Act claim. Now, if you maintain this neutral and helpful position, then you're essentially at no cost risk, and you'll usually be allowed to take your modest costs out of the estate. But if you overstep the line, there are reported cases that come down hard on personal representatives and make adverse cost orders against them personally. As I'm sure you all know, it costs a lot of money to run an Inheritance Act claim to trial, so that's quite a lot of money that you'd be gambling. The final thing to talk about is how Inheritance Act claims are resolved. Basically, they're either resolved out of court or in court. Starting with out-of-court resolution, it's often helpful for professional or professionally advised personal representatives to be kept in the loop on any settlement discussions, so they can check that the compromises that are being discussed are in fact workable. But don't let this prejudice your neutrality. You should be facilitative, not obstructive. At the very least, you should be available at the end of a phone if there are any roundtable discussions going on or mediations. If the claim is resolved by court, by an order, then obviously, as personal representative, you should abide by the terms of that order. Also, an important point to bear in mind, once a claimant has succeeded and an order has been made, the personal representative owes that person the same duties as any other beneficiary of the estate. So you can't treat them any differently. And that is a whistle-stop tour of dealing with litigation as a trustee and PR. I'd welcome any questions, but for now, I'll hand you back to Olivia.
Great, thank you. So if you did enjoy this webinar and would like some more private client talks from Radcliffe barristers, then I'm told that there are some tickets still available for our private client conference, which is taking place on Tuesday, the 14th of October from 12 till 8 o'clock. And just some general information, admission tickets are available at £200 plus VAT and an Eventbrite fee. Some of the topics that will be covered are dealing with vulnerable clients during litigation, genealogy and the courts, from heir hunting to kin inquiries, cross-border succession and insolvent estates. So if that sounds like something you'd be interested in, then there are more details on how to book on our events page on our website. And thank you all for listening to this webinar. We hope you have found it interesting and useful. And we hope that you have a great rest of your day.